All right. All right. All right. Well, welcome, everyone, to Gresham Chapel here at Woodward Academy. All right. I am your anchor and host, Brian Keith Jackson. Today, you will observe a simulated Supreme Court experience. We have several cases on the docket today, and for the next several days, which will be argued by students in my government econ class. The two cases we have on the docket are Florida versus Harris and Florida versus Jardines. Here's how it's going to work. Students from my government econ class have spent the last 3 months writing and researching current Supreme Court cases. These students have been assisted by Woodward Academy champion debate coaches, Ms. Maggie Berthume, here to my left, and Mr. Bill Batterman, here on my right. They've been further assisted by senior varsity debate members, Alex Dunner, Sahil Patel, Zoe Rosado, James Walker, and Karthik Srinivasan. The students will play the role of lawyers using skills learned and honed over the past 3 months. The students in my class will take their shot at trying to convince the student judges, the gallery audience here at Gresham Chapel, and you, our digital audience who are watching on WA Live via the internet, that their side should win. Following oral arguments in front of the Supreme Court, we will cut away back to our studio on WA Live Court TV version. We will have color commentary by our esteemed guests here. And depending upon when you watch later on this week, we also have some special guest commentators. We will have audience participation here in Gresham Chapel. It will occur in a variety of ways. Audience members here in Gresham Chapel will be able to vote using their personal devices which attorney they believe did a better job. They'll be able to vote about who they think the Supreme Court will rule for and why. Our digital audience, you out there, will also be able to participate. You may chat with me online, real time, by using http://todaysmeet.com/BKJ. So that would be todaysmeet.com/BKJ. And you'll be able to chat with me live while the arguments are going on. Now, students from Mr. Broad's video class and my government class will play the role of judges. And in this particular period, we also have judges from Ms. Berthume's and Mr. Batterman's debate class. They would play the role of judges, and they will render their verdict following the oral arguments of the cases. These cases are real. They are currently before the United States Supreme Court, and no one really knows how the actual U.S. Supreme Court is going to rule. All right, so without further ado, let's kick off Supreme Court Week, first period, and Black History Month here at Woodward Academy. I hope that you enjoy the arguments you hear and that you learn something along the way. All right, now, Mr. Batterman, let's start with you. You are a former government attorney. Tell us a little bit about the cases that we're about to hear today, Florida versus Harris and Florida versus Jardines.
Okay, well, we've got two cases before the court today, both involving Florida and both involving drug-sniffing dogs, which is an issue that the Supreme Court has discussed or ruled upon 3 times previously, each time ruling that a search by a drug-sniffing dog does not constitute a search under the Fourth Amendment. The first time the court ruled was in 1983 in United States v. Place. They ruled again in City of Indianapolis v. Edmond in 2000 and in Illinois v. Cabayas in 2005. And each time they ruled that a search by a drug-sniffing dog was not something that individuals can be protected from by the Fourth Amendment. And the court today will have to decide whether that precedent stands or whether the previous decisions will need to be altered or overturned.
Okay. Ms. Berthume, will you please tell us a little bit about the cases from your perspective?
Absolutely. The two cases that we're going to hear today both hinge on in what elements a drug-sniffing dog may be used. In Florida v. Harris, the issue is training of the dog,
okay.
Whether dogs need to, how rigorously the dogs need to be trained, and in particular, whether judges have the right to know the previous record of that particular dog when making determinations about whether probable cause applies based on that dog's indication that an illegal substance is present. Second, in Florida v. Jardines, there's a question of whether there is a greater expectation of privacy in the home, whether a dog can be used to sniff at an individual's home, or whether that only applies in a more public space like an airport or in a vehicle.
All right. I think I hear the Supreme Court Justice is about to proceed, so we'll cut away from Woodward Academy Live Court TV and go straight to the courtroom where the justices are about to enter to discuss these particular cases.
All rise. You may be seated. The United States Supreme Court is now in session. The Honorable United States Supreme Court Justice presiding. The two cases on the docket are Florida versus Harrison and Florida versus Jordan.
Is the attorney for the state of Florida ready to proceed?
Yes.
Is the attorney for Harris ready to proceed?
Yes.
The attorney for the state of Florida, you have the court.
Yes.
You may.
In the summer of 2006, Officer Wheatley and his well-trained narcotics dog, Aldo, were on routine patrol. Officer Wheatley stopped the respondent, Clayton Harris, for an expired tag. The officer noticed Harris was shaking, breathing rapidly, and could not sit still. Overall, the respondent was obviously nervous. In addition, the officer noticed an open beer can in his vehicle. So because of his nervous manner and his refusal to consent to a search of his vehicle, Officer Wheatley pulled Aldo out of his car, and his search dog began to perform a free air sniff. During this free air sniff, Harris was frantically moving around his truck. It was almost like he was in a state of panic. Aldo then became alerted and sat near the driver's side door handle. Officer Wheatley then advised Harris that he had probable cause to search his vehicle. During his search of the vehicle, Officer Wheatley found massive amounts of pseudoephedrine and matches hidden throughout the vehicle, which is commonly used to cook up methamphetamine. After this find, Officer Wheatley placed Harris under arrest for possession of listed chemicals and read him his Miranda rights. After placing him under arrest, the officer continued to search his vehicle and found a bottle of muriatic acid, 2 bottles of antifreeze, and a coffee filter filled with iodine crystals. Based on my analysis, Officer Wheatley's actions in this case were completely within boundaries of the Supreme Court's Fourth Amendment jurisprudence. In addition, his actions were consistent and in keeping with police practices nationwide.
Attorney, if I may, you said this was a routine check for the policeman. If this was just a routine check,
Yes.
Why did the officer feel the need to bring a drug-sniffing dog to the presence of the car?
First off, because of his nervous manner, and he also had an open can of alcohol in his car. And after seeing the open can of alcohol, he asked to search his vehicle. And once he refused, he then pulled Aldo out of his car.
May I also follow up with that? What is the, procedure for when dogs are to be brought to sniff the car like that? It seems like if only a beer can is found, why is that enough probable cause for drugs?
Wow.
Why is the presence of a beer can probable cause for a drug-sniffing dog?
See, it's not. You do not need probable cause to search the outside of the vehicle, since you're not searching anything within his vehicle and personal of his.
So there is no preset procedure for under what conditions it is okay for a policeman to let a drug-sniffing dog sniff a car outside the car?
Yes.
Okay, then what would you have this court rule today?
In conclusion, I would like the court to, based on my analysis, the Supreme Court should rule that Aldo's alert to the exterior of Harris's car did in fact provide Officer Wheatley with probable cause to conduct a warrantless search of the interior of the vehicle. The Supreme Court should reverse the Supreme Court's Florida's previous decision to suppress the evidence. Officer Wheatley's search did not violate Harris's Fourth Amendment right protecting against unreasonable searches.
On the question of suppressing evidence, what is the track record of drug sniffing dogs in Florida in terms of how they are trained, and what is the accuracy rate of the drug sniffs?
And also, what drugs was Aldo trained to sniff?
Aldo's was trained to sniff all kinds of drugs, including methamphetamine. Could you please restate your question?
How accurate are drug sniffing dogs, and what is the training that the dogs go through before they're used out in like real crime situations?
Detection dogs go through a vigorous amount of training. First, they have to be certified by they have to first be trained and then certified by I can't think of the word.
But they
have to be certified.
There's some agency that has to do all that.
Yeah.
What's the qualifications for a dog to be certified?
They have to go through a 40-hour training course prior to being certified.
Is it possible for a drug sniffing dog to register a false positive? In other words, act as though they found drugs, but they haven't detected anything. In other words, that the dog is wrong, dog is incorrect. Is that possible?
For them to
for the dog to have an alert, say that the dog barks, acts excited that they've actually detected drugs, but there's no drugs there.
Of course, there's. Oh, I'm sorry. Go ahead.
That there's a false, in other words, a false positive. It's like where a test result for a patient comes back and it says the person's got some disease where they're perfectly healthy. Which can happen.
Or in other words, is it possible for the dog to be wrong?
It's possible for the dog to be wrong, right?
Of course, there's always a fraction of the time the dog could be wrong.
What fraction of the time? Like, what is the percentage that drug sniffing dogs are wrong?
And how low does that fraction have to be in order for it to be a valid piece of evidence in a court?
I'm not quite sure what the Aldo's
So, like, presumably, if the dogs were right 50% of the time, would that be a high enough standard, or does that have to be lower, say, like 25 or 10%, incorrect to be valid evidence?
The dog has to be correct more than 50%.
Are the dogs trained to detect alcohol? In other words, are they trained to not just, let's say, cocaine, heroin, but also alcohol? Or do you
just drugs?
Just drugs, but not okay.
What about the iodine crystals or the matches? Was he supposed to detect those?
No.
Okay. So what is it in the car that the dog detected?
What is it?
Yeah. Because there were only the chemicals to make meth, not the meth itself.
Could you restate the question?
Yeah. What did Aldo detect in the car?
I'm not quite sure.
Can you please repeat what was found in the car upon the policeman's search?
Upon the policeman's search, he found approximately 200 pseudoephedrine pills, 2,000 matches, a bottle of muriatic acid, 2 bottles of antifreeze, and a coffee filter filled with iodine crystals.
So the only thing that the dog would have been alerted to is the pseudoephedrine. Because those are the only things that were in drug form in the car.
Yes.
And you stated that there was an open beer can.
Yes.
Would Florida law allow, would that be probable cause enough, even if the dog was not there, would that be enough probable cause to search the car under Florida law? Do you know?
Of course, it's illegal in Florida for a person to have an open can of beer in the car, because he has something illegal in the car. He could have more than one thing that was illegal.
So I guess what I'm saying is if there was no dog, if there was no drug sniffing dog, and I'm the policeman and I stop you and I see the open can, and we're in Florida, and is that enough probable cause? Is that probable cause under Florida state law enough of it to search your vehicle and find, let's say, and then by doing that find all these other drugs which were found?
Yes, I'm pretty sure.
Are we ready to hear from?
I have one more question.
I think we're ready to hear from the counselor for arguments.
Okay.
Go ahead. Ask your question. Go ahead.
If it was just the pseudoephedrine that alerted the dog to the presence of drugs in the car, what is the threshold for the amount of pseudoephedrine that would have had to be in the car to alert the dog?
I'm not sure if I understand your question.
Okay, so pseudoephedrine is found in Sudafed, basically.
Yeah.
And there were a lot of pills that contained Sudafed in this car. How many pills would have to be in the car to alert the dog to the presence of drugs during a free air sniff?
I'm not quite sure of the exact amount.
All right, that's all.
Is the attorney for Harris? You may proceed. You have the court. Excuse me.
In June of 2006, my client, Clayton Harris, was pulled over at a routine stop for expired tags on his car. After being caressed by the policeman and interrogated, my client was nervous. The cop thought that because my client seemed jittery, my client had been hiding illegal substances in the car and or had been participating in illegal activities. Officer Wheatley went back to his police car and brought out his police dog, drug-sniffing dog, Aldo, to conduct a legal air sniff around the car. The dog alerted the door handle on the driver's side. Officer Wheatley thought this was probable cause, so he searched my client's car, and the police officer found over 200 pseudoephedrine pills, 1,000 matches, and other ingredients used to manufacture methamphetamine.
Counselor, has this Supreme Court not already ruled that the use of a drug-sniffing dog is not considered search and seizure under the Constitution? And if so, then why are we here?
May you please restate the question?
The Supreme Court has already ruled that a drug-sniffing dog is not a search and seizure from which citizens should be protected because it's not intrusive enough. Given that that is true, why are we here?
Because on a false alert, drugs were still found in the car, but because it was a false alert, the dog was not trained to sniff pseudoephedrine pills or matches or any of the other ingredients to make methamphetamine. It was also not trained to sniff alcohol, and open containers are irrelevant.
How is it a false alert if drugs were found?
Because the dog was not trained to sniff out any...
Not trained under what standards?
Exactly. There were no standards for any...
So it's not that the dog was not trained at all, but rather...
The dog was not trained to a sufficient standard or a national standard.
Why should we have... Why is a national standard needed in order for evidence from drug sniffs to be considered? Like, why should we have a consistent standard for measuring accuracy?
Because it needs to be more accurate, and dogs need to be able to stay on top of their accuracy and be 100% accurate every time, because drug sniffing dogs have a 50% success rate.
So to return to this case, Aldo was trained, though not to a national standard. And
Well, we were just, not necessarily, just there wasn't a standard, it's my understanding.
was the dog Aldo trained at all to alert to the presence of drugs?
The dog was trained by Officer Wheatley, and he did complete the 48-hour training and got the certificate to become a drug sniffing dog.
So he did go through some standard to
He went
become
through some
a
standards.
classified drug sniffing dog.
But the standards were not measured or compared to any other standards nationally or otherwise in the state of Florida.
Given that he was somewhat trained and that the instance of this case is not a false alert as there were drugs found in the car, what is your client's complaint?
May you please restate the question?
Given that the drug was certified to sniff under some standards and that it was not a false alert in this instance, what is your client's complaint?
I'm not saying that it was a false alert, like there were no drugs in the car, but it was a false alert because the dog was not trained to sniff anything in the car that was found in the car. And 3 months later, after the incident, Harris had nothing in his car, and he was stopped again by the same officer with the same dog, and the dog alerted in the same spot 3 months prior. So that.
Okay. I think we're. So.
Thank you.
The state of Florida, you have 1 minute for rebuttal. Do you want to take your rebuttal, or do you waive rebuttal? Okay. You may approach.
In 1925, in the case of Carroll v. United States, the Supreme Court held that a warrantless search of a car or any other vehicle based on probable cause to believe that the vehicle contains illegal drugs is not unreasonable. The reason automobiles are an exception is the mobility of the vehicles as well as the lower expectations of privacy. In another case, exactly Florida v. Royer in 1983, the Supreme Court recognized that an alert coming from an officer's well-trained detection dog can establish probable cause to search the object of the dog's alert. I'm done.
We have a second case, Florida versus Jardines. Is the attorney for the state of Florida ready to proceed? Is the attorney for Jardines ready to proceed? The attorney for the state of Florida, you have the court. You may.
In Miami, Florida, in 2006, a police officer by the name of Detective William Pedraja received an anonymous tip that Jolise Jardines had been in possession of drugs. After this, he went with another police officer and a drug detecting dog named Frankie to his home. They surveyed the house for 20 minutes and then left. When they came back, they brought Frankie with them, and they brought him to the front porch of Jolise's home. The dog detected drugs in the home, and so they arrested Jolie Jardines. Jardines is arguing that they are violating the Fourth Amendment, but it has been ruled 3 times in the cases the City of Indianapolis versus Edmond, in U.S. versus Place, and in Illinois versus Cabales, that a dog sniff is not a search under the Fourth Amendment. The reason is because it is so limited and so unique. It does not sniff anything else but drugs. Also, surveying the house is not a search either. Jardine still argues that they violated his right of privacy, but no one, in fact, has the right of privacy to drugs, even if it isn't.
I guess, why should a dog be allowed to sniff on, like, the porch? Like, I guess, how far away from the house does a dog have to be in order for the drug sniff to be accurate or successful? Do you have any, like,
Well,
any...
I know that
range, like how close to the house do they have to be? Do you have any idea?
I don't know, but I know that Frankie was on the porch by the front door.
So I guess why should the court rule that it's okay for a dog to come that close into your home? Like, why is the porch not your house?
Well, it is your private property, but they did not disturb anything. They did not enter the home. And like I said before, no one has the right of privacy to drugs.
Counselor, what would you have this court rule today?
I would rule that Florida win this case because they did not violate the Fourth Amendment. They did not go against the law.
So in terms of the constitutionality of a drug-sniffing dog, they should be allowed to come all the way up to a house and on the surrounding premises to sniff.
Well, they had a probable cause from the tip, and when they surveyed the house, they noticed the blinds were cold and closed, and the air conditioner was running nonstop for 15 minutes. And so, since they had probable cause, they could go to the front of the house. They didn't have a warrant, but they didn't enter the house or disturb it.
So Florida law says that that a dog can come up to the front door and sniff, that they don't have to be as far away as the curb, or let's say you're the front door and I'm at the curb. It doesn't have to be that far. It can be all the way to the front door, but that's not violating the Fourth Amendment. By having the dog walk onto the property, let's say there's the grass between me, I'm the curb, and you're at the front door. And the grass on my property that's not violating the Fourth Amendment by having the dog and the policeman walk onto the grass up to the front door.
No, because a dog sniff isn't considered a search under the Fourth Amendment.
What about the policeman walking onto the property? That's not a violation either?
He wasn't doing the searching or detecting for that. He just brought the dog to the front door.
Thank you.
The attorney for Jardines, you have the court? You may.
Good afternoon, Your Honors. I am representing Mr. Jardines as defendant in the case of State of Florida versus Jardines. Let me state that my goal here is to ask you to uphold the State of Florida trial court's verdict that the search warrant used to gather evidence against my client violated his Fourth Amendment rights. My client, Mr. Jardines, was charged with growing cannabis and theft of electricity. In the original case, on December 6, 2006, a Florida detective by the name of Detective Pedraja received an anonymous tip from Crime Stoppers that the defendant Jolie Jardines' home was being used as a facility to grow cannabis. 1 month after receiving the tip, Detective Pedraja went to the house and observed from across the street and subsequently called the K-9 unit, which consists of drug detection dogs. In his opinion, there was sufficient evidence to bring in a drug detecting dog, who was guided by a detective named Bartlett. When Detective Bartlett arrived at Jardines' home, he placed the dog on a leash and walked to the front door of the home. At this point, the dog alerted Detective Bartlett that there was cannabis inside the home. When he walked back to Detective Pedraja, he told him that there was, in fact, cannabis inside Jardine's residence. After hearing this, Detective Pedraja went to the front door and picked up the scent of cannabis. The detective also concluded that having the heater on in weather that was already hot was an indication that Jardine had been growing cannabis in his home. Soon after performing the sniff test at Jardine's residence, Detective Pedraja wrote an affidavit of the findings and subsequently applied for a search warrant, which was issued.
I guess the cause, like the reason you got the search warrant was that the dog had smelled the cannabis, right?
Yes.
So why is it bad for the dog to come like up alongside the property?
Well, originally they were observing from a public street and a public curb, and he actually went onto Jardine's property.
So the the crossing the line onto the property is what
yes.
you're
He
arguing?
owned the front yard, and therefore it was trespassing. And Jardine's wasn't there for them to ask him if it was okay to search his house.
Okay.
In my opinion, Detective Bartlett, with a disregard, knowing that Jardine wasn't there, took the opportunity to go and falsely accuse him of a crime.
Would the search warrant have been issued absent the dog sniff? So was the rest of the evidence, like the officer going up?
There was not sufficient evidence to issue a search warrant solely on the Crime Stoppers report because that source was unidentified and therefore not valid.
Does the police officer need probable cause to take the dog onto the property to search?
Yes.
Or why do we know that the dog did not smell something on the curb?
He did not smell anything on the curb.
So given that this court has already ruled that a dog sniff is not a search, and that a detective would therefore not need probable cause to allow a dog to undergo a free air sniff of the surrounding area, what right was violated by the dog sniff?
Well, I disagree that a dog sniff isn't a search because in the case of State versus Rab, what happened was that it was really similar. An anonymous tip was called in. The sheriff began investigation on John Brown. The surveillance of his residence began. Mr. Brown was intentionally followed and pulled over for an illegal lane change. He was told that they were conducting an investigation and proceeded to ask him if he was growing cannabis in his home. A sniff test was performed in the interior of his car by a drug-sniffing dog, and detection proved positive. Mr. Brown was then arrested for possession of cannabis.
Counselor, what would you have this court rule?
I would have them rule in favor of Jardine because this search was unconstitutional and
Would
violated
you have
his
us rule
rights.
that all dog sniffs should be classified as a search under search and seizure in the Fourth
Yes.
Amendment? In any circumstances?
It depends on the circumstances.
Why is the search of the home different from the search of the car in the previous case, or should it?
He was already a suspect that he was growing cannabis in his home. The fact that they found it in his car, they felt that they should be able to go and search his home.
Is there not something unique or valuable about the home and the privacy that we have in the home that when we go in a car we're willingly giving up that privacy, but in the home we have a higher standard for what we should constitute privacy as? Because it seems to me like the state of Florida violated his right to privacy in his home.
Well, it was definitely a violation of his privacy. He wasn't even there to object to the search, and he wasn't there to request a search warrant.
Why does he have a privacy to the use of drugs?
It was in his home, and you have the right to your security in your home.